Okay, so thank you very much for coming to this extra special, ad hoc, extracurricular webinar following the judgment last week in the joined cases of Elkundi and Birmingham City Council and Imam and the London Borough of Croydon. So I have with me Zia Nabi, who acted for Mr. Elkundi and others, together with Joseph Marcus of Garden Court North Chambers, and Martin Westgate, QC, who acted for Ms. Imam with me. So we will have Zia first, talking about the Elkundi case, and then Martin will talk about Imam and the decision in relation to the grant of mandatory relief in suitability cases. After that, there's going to be a pop-up on your screen which asks you 3 questions, and I promise it's just 3 questions, asking for feedback. I promise it will only take a moment, but after you have stroked our egos and told us how brilliant we are, as we anticipate you will, after you've done that, then there'll be an opportunity to ask questions, and we'll try and put this in a little bit more practical context. You will see that you are muted. If you do have questions, please put them in either the Q&A or in the chat function, and don't hold back. Feel free to ask questions at any time, and we'll deal with them when a good moment arises. So without further ado, I'm going to hand over to Zia Nabi.
Hello, good evening, everyone. And thanks for turning up to this. So I'm going to be speaking on the judgment in the Elkundi appeals, and Martin, as Sarah said, will be dealing with Imam, which concerned relief. Elkundi very much concerned the nature of the main housing duty and what it obliged a local authority to do. Please, could I have the first slide, Ray? So, it's always helpful to start off with what the section actually says. And it's a section we all know, but what it says is that unless an application is referred to another local housing authority under local connection provisions, they shall secure that accommodation is available for occupation by the applicant. And really the appeal, Birmingham's appeal, turned on what was meant by shall secure, and they put the emphasis on shall, and what was meant by available. What did this section actually oblige them to do? Please, could I have the next slide? So what was Birmingham's case? Well, it was a bold case, in my view, bearing in mind that for a long time, the orthodox position, really, I would say, had been that the duty was to provide accommodation immediately. But Birmingham said, no, that was wrong. What Section 193 required was that housing authorities were to secure accommodation was available within a reasonable time of the duty arising, i.e., it was not an immediate duty to secure accommodation. And well, what was reasonable? They said, well, the reasonable of the period depended on the circumstances of the case, so it's very fact specific on each case, and the accommodation that was available. So you can see that this was a potentially very difficult argument for homeless applicants, because if Birmingham were right, it meant that there was no immediate duty to secure accommodation, and a period could extend to years without the authority being in breach of the duty. And so you don't need to provide accommodation immediately, said Birmingham, because the statute used the word shall, and they introduced extracts from dictionaries as to what was meant by shall in statutes, and referred to various cases, not housing law cases, I hasten to add, where shall had been taken to mean that something that would happen in the future rather than immediately. And they said it was clear that if you looked at the subsection 1932 in a straightforward way, that Parliament clearly intended that the authority would make arrangements for the provision of accommodation in the future. And they said that the respondents, Mr. Elkundi and his fellow respondents, and the judge below had got it wrong by interpreting the statute as they had. Please, may I have the next slide? What did the court decide? I mean, there's not really very much to say here. Birmingham initially wanted 3.5 days to hear this appeal. And we thought, well, actually, it could probably be done in 2 days. And once Imam joined, the Court of Appeal agreed. And so we were given 2 days. And actually, from memory, I think we finished in slightly under 2 days. And the court didn't think that this was a very complicated or lengthy point. They recognized it might be important for a housing authority, but they thought the point was quite short. So what did they decide? Well, they decided that the duty is non-deferrable, that it's an immediate and unqualified duty to secure that suitable accommodation is available for occupation. And that's it, really. And they said it's not a duty to ensure that accommodation will become available within a reasonable period of time. It's a here and now duty. It's here to assist homeless people. And the court wasn't sympathetic to a submission that there could be a period of time when the authority was required to do nothing at all in terms of providing accommodation. Section 1932 said the court is a result, imposes a duty of result. The result is to provide, to secure accommodation is available for occupation. You cannot have a hiatus between effectively the duty arising and the performance of the duty. Both of those things are coincidental. May I have the next slide? But what is suitable accommodation? And here the court said, well, things aren't as bad for the local authority as they might fear, given their lack of resources. The court said suitability is a flexible concept. Now, to be fair, this is not news. We've known this since Ali and Birmingham City Council back in 2009, when this is what the House of Lords decided. And the court said different accommodation may be provided at different times to ensure that the duty is being performed. And what is suitable may evolve or change over time, depending on all the circumstances. Something could be suitable for 2 weeks. It could be pretty low standard. It could be bed and breakfast, but it might not be suitable for, say, a year, because the duty, until it can subsist for, as we all know, for quite a significant period of time. And critically, what the court said is this, so that if the authority itself decides that the accommodation that's currently being occupied is unsuitable, then it must immediately provide other accommodation which is suitable until the main housing duty comes to an end. So very straightforward, actually. It doesn't require any tortuous construction. It's the main housing duty is meant to be a quite straightforward and simple duty. Well, it's got more complex with all the amendments to the Act that we've had over the years. But 1932, as was pointed out in the appeal, has remained unchanged since the 1996 Act came into force in February of 1997. May I have the next slide? Another issue in this appeal was, could you waive your right to suitable accommodation? I'm afraid, sadly, advisors may be familiar with the argument that the homeless applicant has waived their right to suitable accommodation because when they initially applied as homeless and they were asked, do you want accommodation whilst we investigate your application? And they said no. The local authority then transposes that onto even after it has accepted the main housing duty and said, well, you waived your right at the beginning, and therefore you've continued to waive your right to suitable accommodation. And that is what had happened in Mr. Al-Shamiri's case. He was really living in dire circumstances, but he had applied as homeless. His wife was an assured tenant of plainly unsuitable accommodation. And when the person who interviewed him had said, "Do you want interim accommodation?" whilst we investigate, he had said no. And the court recognised that that was quite sensible because, firstly, he might have been given bed and breakfast accommodation anywhere. Secondly, the authority might not have accepted a homeless duty, and he would then be in a position where he'd given up the assured tenancy. His wife had given up her assured tenancy, and they'd be left with nothing. And in Mr. Al-Shamiri's case, the authority, when it accepted the main housing duty, sent out a pro forma letter, quite a lengthy, complicated pro forma letter, which in the middle of it had 1 or 2 sentences saying, "You've waived your right to be provided with accommodation, even after acceptance of the duty. And if that's not right, then let us know." And I expect most people simply wouldn't have picked up on that sentence in the middle of this 4 or 5 page letter. And he certainly didn't. And in the court below, Mrs. Justice Steen had found that Mr. Al-Shamiri hadn't waived his right to suitable accommodation post acceptance of the main housing duty because he hadn't given fully informed consent. He'd never been asked after the main housing duty was accepted in terms, "We have a duty to provide you with suitable accommodation. We accept you're not in suitable accommodation at the moment. What do you want to do?" And the Court of Appeal said, well, Mr. Justice Steen was right. Mr. Al-Shamiri hadn't waived his right to suitable accommodation on the facts because he'd never been placed in a position where he could give fully informed consent. So this is a very helpful bit of Elkundi, the judgment, I think. And the second helpful point that the court made is this. If you waive your right to suitable accommodation, it's not a once and for all waiver. Now, you would think that's quite self-explanatory, but here the court has set it out in black and white. And if a person subsequently changes their mind and says, "No, I would now like suitable accommodation," the waiver comes to an end and the authority comes under an immediate duty to provide suitable accommodation. May I have the next slide? Well, what about Birmingham's system for how it provided accommodation to homeless people? Was that system unlawful? Answer, yes. And it was unlawful in 3 main ways. Firstly, and this took up quite a lot of time in the hearing before Mr. Justice Steen, because it was really difficult for us to understand what system Birmingham were operating. They referred in correspondence in various cases obliquely to something called a move-on list, and also referred to a homelessness policy, a policy that was never produced until the Elkundi judicial review. Then they produced a policy, and 2 witness statements later said, "Oh, we're so sorry, we haven't actually got a policy. That was just a draft policy that was never approved." And when we've been referring to the move-on list in all the pre-action correspondence, that's nothing more than a spreadsheet. It's a list of people who are waiting for accommodation. And that was their system. And the court upheld Mrs. Justice Steen's finding that this system was unlawful because it placed applicants who were owed the duty and who were in unsuitable accommodation now in the same list as people who were in suitable accommodation for the short term or for the medium term. So there was no distinction between people who were in unsuitable accommodation at the moment that the decision is made and those people who might be in unsuitable accommodation at some point in the future. Secondly, their system was unlawful because it was predicated on Birmingham's understanding of the statute that they had a reasonable time to find suitable accommodation. And Birmingham had accepted, both in the court below and in the Court of Appeal, that if they were wrong on the nature of the duty, then their system was unlawful. I was really surprised at this because I hadn't really appreciated until the Elkundi judicial review that the system being operated by the council was predicated on the basis that they had a reasonable time to find suitable accommodation. Now, I don't know how many other authorities are approaching their duty in the same way, but that is something that only became clear in the middle of the judicial review. And finally, the court said the system breached the public sector equality duty because there was no evidence produced by Birmingham that they'd had regard to the impact on a disabled person or a disabled household of the period of time spent on the waiting list for suitable accommodation. There was no equality impact assessment, and there was no monitoring as to what the effect of Birmingham's policy, this move on list, was on households with the protected characteristic of disability. So those were three ways in which Birmingham's system was unlawful, and Mrs. Justice Steen's declaration was upheld. May I have the next slide? Can accommodation be unsuitable, found to be unsuitable by an authority? Can an authority then change its mind and say it's suitable simply by writing you a letter? Now, that wasn't an issue that arose on the facts of any of the appeals. Mrs. Justice Steen acknowledged that and made an obiter finding that the authority would be functus once it had found that accommodation was unsuitable. It couldn't then decide without more that the accommodation was suitable. That wasn't necessarily the end of the story for the authority, because all it had to do was to make a formal offer of the same accommodation again, saying that it was suitable, and then that offer would attract the right to request a review and also, if necessary, go for home statutory appeal. And the Court of Appeal declined, despite Birmingham's invitation, to reach a finding on this issue. They did say that Mrs. Justice Steen's obiter finding in the court below shouldn't be taken to have been approved by the Court of Appeal and shouldn't be the starting point in any case where this point would be decisive, i.e. it was necessary for the decision. And so they've said, don't start with what Mrs. Justice Steen has said. Don't assume that she's correct in her view that the authority would be functus, but it was acknowledged by Lord Justice Lewis that it could be the case that only a fresh decision could only be brought about by making a fresh offer of accommodation on the basis it was now suitable. So that's something that's been left in the air for another day. May I have the next slide, please? Now, Martin is going to be saying a lot more about relief, but in terms of the Elkundi appeals, there was one of the four claimants who needed mandatory relief at the time that the judge came to give her judgment, and he got mandatory relief. Did the judge err in granting mandatory relief? No, says the Court of Appeal. In Mr. Ahmed's case, he'd been owed the duty for 16 months. The judge had carefully assessed the impact of the lack of suitable accommodation, both on him and his family, and she determined that it was not unreasonably difficult for Birmingham to comply with the mandatory order. I'll be very interested to hear what Martin has to say, but that unreasonably difficult, I would like to argue, it's a quite high hurdle for a local authority to get over, just as it is very difficult for appellants to show irrationality or saying that an authority is behaving unreasonably. It should be the same the other way around as well, I would suggest. And that it really needs very cogent, very powerful evidence before an authority can have the defense of unreasonable difficulty. And in this case, I think the Elkundi cases are helpful because the court sets out the really dire circumstances that Birmingham were in. You know, they've got a very long waiting list of people who are owed the main housing duty. People are in unsuitable accommodation. They put in a lot of evidence about how they had very few large houses, or they had very few houses that were adapted for disabled families. And despite all that, the court made a mandatory order saying that accommodation had to be provided in 12 weeks' time. So that is something to hold on to. May I have the next slide, please? Does the judgment say anything else at all? Well, there's a little interesting point in this judgment where Lord Justice Lewis, referring to Anslo Meso, said it is good practice for a local housing authority to have a policy explaining how properties are allocated to homeless applicants. So this is not the Onslow Maser point where the local authorities was advised to have a policy explaining which people would be accommodated out of the borough and which would not. This says it's good practice to have a policy explaining how the homeless duty will be performed for homeless applicants. And although the judgment doesn't refer to it, in my view, this fits in very neatly with the homelessness strategy duty that local authorities have. And so in cases where the local authority is arguing that they've got nowhere, and therefore you're just going to have to wait, in my view, it'd be a good idea to A, to ask for the homelessness strategy, and B, to ask for the policy that they have, which explains how homeless people will be accommodated. Right, well, I think that's all I have to say on Elkundi, and I'm going to hand over to Martin.
Now that I've unmuted myself, thank you. In Imam and Croydon, there weren't the many issues that arose in Elkundi. There was just one question, and that was whether the deputy judge, Matthew Gullick QC, had erred in not making a mandatory order when he'd been asked to do so. And if I can just start with the first slide, please, just to show the timeline. And I mean, this is very attenuated, but very briefly, the facts were that Ms. Imam was a wheelchair who had 3 young children at the time, not so young now. And she applied as homeless, and Section 193 duty was accepted. And in October 2014, she moved into a 3-bedroom property. As the judge found, there were some positive aspects to it, but one of the big problems was that the only bathroom was on the ground floor, and that caused difficulty for Ms. Imam. And when she applied for a review of the suitability of that accommodation, after some toing and froing, the council accepted on the 5th of June that the accommodation wasn't suitable. And interestingly, they did that in the face of a letter from Ms. Imam's solicitors that expressly drew their attention to the possibility that they might decide that the accommodation was suitable for a short period, but not for a longer period. But Croydon said, no, it's not suitable now. And time went on. There were some limited offers, none of which were suitable. And it can't be said this is a case where the Ms. Imam and her solicitors rushed into court unreasonably. They made the application for the mandatory injunction nearly 5 years after the council decided it wasn't suitable, 5.5 years after she moved in. It didn't come to court until almost exactly a year later. And so we're getting on for 6 years by that stage. But nonetheless, the judge managed to find that this wasn't a case where an order should be made. So how did he do it? Can we go to the next slide, please? The judge's reasons were he took into account the length of time. He agreed that would point to an order being made. But he held that there were a number of factors that pointed against that. One was he took the view that this wasn't a breach at the very top of the serious end of the range. He said there were some good things about the property. And particularly, he was taken by an argument that was run by Croydon, that if you select various words from the judgments of Baroness Hale and Lord Hope in Ali, that produced a test that something had to be intolerable, and the claimant had to show it was intolerable, that enough was enough before an order should be made. And he also took account of the fact of the dire position Croydon's in. There was a statement from the council that ran to 35 pages explaining that sort of difficulty. And he also took account of the limited resources available to Croydon. At the time, I think Croydon was between various acts of bankruptcy and had a projected overspend of £67 million. But he also took account of various points that were made to the effect that there were lots of other people on the waiting list above Ms. Imam, and also that if she were provided with accommodation, that would be unfair to some Part 7 applicants who've been waiting even longer than she had. And they gave some examples of particular cases where people have been waiting sometimes very much longer, even than 7 years. And the judge was fairly well with that, the council had been doing all they reasonably could within the constraints of the resources available to them. And so he dismissed the application. Ms. Imam appealed, and in the Court of Appeal, if we can get to the next slide, please, the broad dividing line between the parties was that the appellant, Ms. Imam, said, well, look, this is about upholding the rule of law. Sorry, can we go to the next slide? Sorry. The appellant made the point, well, look, this is about the authority fulfilling a duty on it. And if they're not going to be required to fulfill duties once they accept they arise, then that's an affront to the rule of law, and the court should, as a matter of principle, require authorities to fulfill their duties, unless they can produce compelling reasons why not. And specifically, it's not right that there was an intolerability test, and budgetary considerations weren't relevant. The respondent, Croydon, stressed the discretionary nature of the remedy, and tried to suggest, well, as long as the authority is attempting in good faith to discharge its duties, then that's a reason not to grant an order, particularly if matters arise from matters outside their control. And it's important to recognise where the authority was going on this, because properly understood, we'd suggest that the Court of Appeal rejects it as an approach, because the authority submissions are very much along the lines that, look, we've got to make difficult allocation decisions. There are far more people applying than can be dealt with immediately. Some people have to wait, and it's up to us to decide who has to do that, even if the effect of that is that some people have to endure breaches of duty while we don't provide suitable accommodation for them. And so, in effect, what their submission was doing was turning the question whether or not you should get an order to enforce a duty into a sort of separate judicial review itself, where you'd have to show that the authority had erred in some way. And the deputy judge appears to have sympathised with that, because he accepted, and the phrase he used was that it wasn't for the court to weigh the claims of the multitude, and that was something that had to be left for the authority, and they were entitled to take account of their broad evaluation about what was fair, and take account of their budgetary restraints. And it's significant that although none of these matters are expressly dealt with apart from budgetary considerations in the judgment of the Court of Appeal, the approach they take is inconsistent with this sort of general idea that the court should defer to the local authority. And that is an important takeaway point, we'd suggest, from Imam. Can we have to come to the next slide, please? So the Court of Appeal allowed the appeal and held that the judge had erred in two particular respects. One was that he'd taken into account budgetary considerations, and the other was that he had wrongly been satisfied on the evidence that the authority were doing all they reasonably could. But before coming to that, Lord Justice Lewis, who gave the main judgment on this point, set out some fairly general principles. And firstly, it's something that can perhaps go unnoticed, but he said that although a mandatory order is discretionary, when it's refused, he explained that that's often because the court relies on the local authority to fulfill its duty. So what often happens is that there'll be a dispute about what the law is. You go to court, the court decides, and they make a declaration or the judgment stands. And they don't find it necessary to make a mandatory order because public bodies are understood, and in a sense, the sort of shared understanding between the courts and those authorities is that when authorities are told what the law is, or they accept what the law is, they get on and they fulfill it. And although the court didn't major on the points that the claimant was making about the importance of the rule of law, this is an important sense of the tone of the judgment, that the function of the court is to ensure that authorities do fulfill their duties. And that is, we would suggest, a foundational block, a building block of what the judgment was deciding. The judge then went on to say that the starting point, and this was accepted by Croydon accepted they were in breach, that the authority was in breach of statutory duty, and importantly, and this feeds into the Elkundi judgment, that a decision on unsuitability had already taken into account matters like housing conditions and the resources available to the authority. So, although the court doesn't put it in exactly this way, if you take those factors into account again when you decide whether or not to grant a mandatory order, then there's an element of double counting, because the authority has already said, well, notwithstanding the pressures we're under, notwithstanding that it's difficult for us, you shouldn't be here any longer, we should find you somewhere else. And that's a situation they've made, that's a decision they've made for the conditions that the person is in when they've made a decision that accommodation is unsuitable, there and then. And that's something that later on in the judgment, the Lord Justice Lewis said the court shouldn't lose sight of that. So we've got a starting point that the courts are there to enforce duties, and that in this case, there is a duty that's already taken account of many of the factors that the authority relies on. Thirdly, and again, it's slightly oblique and a bit hidden away and not expressly stated, but it's clear that the judgment says that the burden's on the authority to show why an order shouldn't be made, and not the other way around. It comes up in a slightly odd passage where they say, well, although the burden's on the authority, they can take account of evidence wherever it comes from. But the clear sense of the judgment is that it's the authority, particularly in the case where there's been a lengthy breach, to show why some order shouldn't be made. And then importantly, what the judge went on to say was that once the duty had been, once the breach had been shown, then financial constraints can't justify non-compliance with the duty, and wouldn't of itself justify refusing to grant an appropriate order intended to bring about compliance with the duty. And that's the words cited there come from paragraph 131, but he comes back to it again at a couple of other points in the judgment. And this was one of the key reasons why they said that the judge erred, because the judge did take into account financial constraints. And that this is it's obviously a significant point, but one of the key difficulties in the judgment, when we'll come on to see, is that on one view, this sort of general statement of principle is undermined by some of the other things that the judge says can be taken into account. So against that background, the judge says, well, the correct approach, and he goes through a number of cases that have used various formulations as to what the right approach should be, whether the authority is in an impossible position, has it taken reasonable steps, is it unreasonably difficult, and so on. And the Lord Justice Lewis came down in the end to say, well, the approach you should take is to focus on whether the authority's taken all reasonable steps to perform the duty. He doesn't in terms say that's the test. Rather, it's a factor that you take into account in deciding whether or not the court should make a mandatory order. But for all reasonable, for all practical purposes, it's the test that he applies. And it's notable that when he discusses the Elkundi decision at paragraph 150, that Zia has already spoken about, he rationalized the language used by the judge in that case as coming to, in other words, a finding that Birmingham had not taken all reasonable steps. And if it had done, it would have been able to comply without unreasonable difficulty, which is what the evidence appeared to show in Birmingham, or at least didn't show the contrary to that. And specifically, he said that the test isn't whether the position is intolerable or enough is enough. And again, that feeds back into the point that it's for the authority to make the decision. But there's a but to this, and if I can go to the next slide, please. But the judge then goes on to identify a number of relevant factors, and he does that partly by saying, just by saying some of them out, and partly by saying that the deputy judge had been perfectly entitled to take these sort of factors into consideration. Now, some of them go to the urgency of the case, and those had long been referred to. And so he said, right, you can take into account how bad the breach is. So in this case, it was all right to say that while there were significant things wrong with the property, also there were some things that were okay about it. It's right to take into account how long you've been waiting. So in other words, the court won't jump in unreasonably. But the longer things go on, the more pressing it becomes, and the more important it is to grant an order. He says you're entitled to take into account the impact on the claimant. So the claimant can't just come along and say, there's a breach, give me an order. The court can weigh what the impact on you is. And importantly, that taking account of whether something's likely to happen in the near future without an order is something to be taken into account. So all of that's fairly standard. But he then went on to suggest, although he doesn't actually say it in terms, that an authority might be able to decide not to use its Part 6 stock to meet all of its Part 7 purposes. It might be able to hold things back. It might be able to have regard to the unfairness to others who've been waiting longer. And importantly, that it might be able to have regard to the limited number of suitable properties. Now, if you have regard to the limited number of suitable properties, there's a simple answer to increasing the number of suitable properties, and that's to allocate more resources to them. And so aren't you, when you refer to factors like that, also saying, well, actually financial constraints can be taken into account, despite what you said previously, and possibly references to all reasonable steps might, if you're going to allow these sort of factors into account, be something that can undermine that general statement of principle. So can we come on to the next slide, please? But what the authority, leaving aside for the time being that difficulty, what the judge held, or what Lord Justice Lewis held, was that the authority has to produce much clearer evidence than they had done in that case. And broadly speaking, what it's got to show is that it's taken all reasonable steps. I think that the emphasis there has to be on the all as much as on the reasonable. And it seems clear that the more significant the breach and the longer it's gone on, the more detailed the evidence has got to be. But what is absolutely clear is that general references to demand and shortage of accommodation and general budgetary pressures simply aren't going to be good enough. And what you have to do is address the specific numbers of properties available for particular classes of user, why they're not used, and so on. In paragraph 134, I'm not going to take you to it, it is quite instructive in that respect, because it shows the judge really getting into the detail as to the type of information that would be needed. In this case, as I said, there was a 35-page statement that went into quite a lot of detail about the budget, how properties were allocated, number of people above them on the waiting list. If you want to know the detail, quite a lot set out in the Deputy Judge's judgment. But it's significant how far the judge was prepared to drill down into the detail of that statement, and to find it to be inadequate in a way that, in one sense, we're not used to in judicial review challenges, where the authority has a certain amount of deference shown to it. And so what it's likely to require is information specifically about what they've done to try and augment stock, what account they've taken of the impact on particularly difficult properties to source, for example, disabled adaptations or large families. What have they done to try and rent properties? What arrangements have they made? Who with? What policies have they got? It may well be, for example, that given the Zia's last point about having a policy for your temporary accommodation, if you haven't got such a policy, is that going to be evidence that you haven't done all that you reasonably could? As the judgment makes clear, the longer all of this has gone on, the more detail that's going to be expected. It might, for example, require the authority to demonstrate what it's done to find accommodation out of borough. Now, that wasn't a failure that the judge found was applicable in this case on the facts. But if there'd been clear evidence that had been an option that had been put out, then it's something that the authority probably would have had to address. And again, that may be an example, a point to take away from the judgment, that if there are positive suggestions you can make when you're acting for someone, then do make them, because that then puts the burden on the authority to have to deal with it. So the end result was that the judge was found to have erred by taking into account budgetary considerations and not requiring enough detail from the authority. And those 2 points can be generalized. I'd just like to finally finish by dealing with some what I think may be some sort of key themes to take away from this. Firstly, that there is this problem about how can resources not being relevant be reconciled with the factors that the court says can be considered. One way of squaring that apparent difficulty might be to say that the key is in paragraph 134 of the judgment, where the judge, Lord Justice Lewis, talks about the appropriate test, and then says that if the authority's taken all reasonable steps, hasn't been able to secure accommodation, that may be a good indication that it's not appropriate to grant a mandatory order, as it may not be possible to secure a suitable accommodation within a specified time. And so it may be that when the authority is talking about resources, then it may be relevant to the time within which an order might be made, rather than whether an order should be made at all. Or it's fair to say that's probably not what Lord Justice Lewis had in mind, and that the answer may not be quite so straightforward as that. But whatever the position is with resources, what does come clearly out of the judgment is that it seems to signal that the court won't be applying the kind of deferential approach to local authority assessments that often apply. And so it's for the court itself to decide whether the steps that have been taken are reasonable, and not to say, well, the authorities reached its own judgment and that's good enough for us. And one gets that from the lack of any reference to deference, and one gets it from the general approach of the court, or the Court of Appeal in this case, where, as I say, they were prepared to drill down and be very critical of the kind of generalizations that the authority adduces in support of not providing accommodation. And the third point that comes out of this, there are many others, but I'll just stick with these three, is the observation that duties trump powers. Because the big point that was taken by Croydon in this case was, well, look, we have to be able to manage our Part 6 stock, and we've got a Part 6 policy, and it's unfair to people on the Part 6 waiting list to make that accommodation available to Part 7 applicants. And the court was interested in this. It spent quite a lot of time exploring the differences between the Part 6 power and the Part 7 duty. And there's also a significant amount of time taken up in Lord Justice Lewis's judgment, explaining that the authority has to give full details about what it's done to make its Part 6 stock available to meet its Part 7 duties. It doesn't go quite so far as to say that as long as there's some suitable stock in Part 6, then you've got to use it in Part 7. But what it does do is require authorities to refocus on the fact that Part 7 imposes a statutory duty where they have to find the resources to fulfill those duties. And if that involves an intrusion on stock that they would rather leave for Part 6, then so be it. And I will stop there so that we have a discussion and questions.
Thank you, Martin. So I think that now the questionnaire is going to pop up on your screen. So please just take a moment to fill that out, and we will get on with questions. So while you're doing that, we'll have a look at the questions. So first of all, this is a question from Charlotte. With the clarification that the Section 193 duty to find suitable accommodation is immediate, but that local authorities can then find accommodation that is suitable short-term to ensure the duty is performed, my concern is that we'll have a sudden increase in cases of applicants being given temporary accommodation swiftly that will increasingly border on the threshold of suitability, as well as leading to more homeless households moving around multiple forms of temporary accommodation due to the accommodation not being suitable in the longer term. Who wants to deal with that? Is that perhaps a question for you, Zia?
Sure. Well, I think that is an unavoidable consequence of this judgment, but it's nothing new. I mean, that has been the accepted law since 2009. It's what Ali in Birmingham said. And authorities have been, certainly recently, been trying to say this, it's suitable for now, and then we're going to move you. Ultimately, it comes down to resources. And if the authority doesn't have the accommodation, effectively, we're playing chicken all the time. But what's important, why Elkundi and Imam are important, is because they've restated the mandatory nature of the duty and the immediate nature of the duty. If authorities do provide unsuitable accommodation, you have a right to request a statutory review and go for statutory appeal. But I perfectly accept that that is an issue. The local authorities may have perhaps were unaware of this legal possibility, can now say, well, we think this is suitable for you for the next however long they say, and then a view will have to be taken.
Zia, can I sort of drill down into that a little bit? If a household is owed the main housing duty, and nonetheless a local authority says your accommodation is suitable for the next 6 months, wouldn't the period of time that the local authority are saying it is suitable for also be part of the analysis that you would then take to the county court on a 204?
Yes, although plainly all relevant factors could be considered. But if they make a finding that it's suitable for 6 months, then you're effectively on an error of law appeal. You'd have to say, well, that was irrational in the circumstances. And my feeling is that judges are going to be reluctant to get drawn into that argument.
Martin, do you want to say anything about that in the context of Ms. Imam?
Well, not so. Well, I think the unfortunately that it clearly is a consequence of the judgments that it focuses a hard-pressed authority on the suitability point of the exercise rather than the fulfillment of the duty point of the exercise. And frankly, that was probably more than a subtext in the arguments in the Court of Appeal. I think they knew exactly that that's what the consequence would be. And it's also maybe, I suppose, people in the seminar will probably know more about this than I do, but if you wouldn't presumably necessarily have to specify the time within which accommodation would be suitable, because it could change from time to time. Even if you say 6 months, by the end of 6 months, you might be able to say, well, circumstances have changed, and we now think you can stay there for longer. But I'm afraid it's I'm afraid that's just a consequence of the judgment.
This next question, I think, is definitely one for you, Zia. Re-waiving your right to suitable accommodation. Can someone now waive their right to a Section 188 offer without the Section 188 duty coming to an end? Or does this duty only commence again if Section 193 is owed?
Right, well, I think there's quite a short answer to that. So waiving your right to 188 accommodation does not bring the duty to an end. Waiver is predicated on the basis that there is a duty, but you're not seeking to enforce it at that particular time. What Elkundi says is, in the context of 193 duty, but it would apply equally to 188, is that if the person then changes their mind and says, no, actually, I would like Section 188 accommodation, the authority must provide it immediately.
Now, unless there are any more burning questions, there's just one more. Gazelle Nazir says, if it's not covered, can advice be given as to how you manage a transfer list of temporary accommodation applicants with different priority/urgency of needs to move to TA? What advice do we give re timescales if there is a list? So, Zia, do you want to answer that first?
All right. Well, it's a very good question, and it's very difficult to answer because, as I keep coming back to, it's all a question of resources. I think a starting point would have to be try to get the homelessness strategy and try and ask if there's a homeless policy for how people are going to be accommodated once they're over. So in your particular borough that you're dealing with, you've got to work out how properties are being provided to homeless people, and keep the focus all the time really on the point that these are duties owed to individuals. They're statutory duties. They're part of the welfare system, part of the welfare scheme. If they're not being performed, then the starting point is you're entitled to relief unless the authority can show very good reasons as to why you're not. My view is that if possible, you want to avoid getting into macro type arguments about policies when you're talking about the individual's right to enforce a mandatory duty. But if there is a scheme like there was in Birmingham, which is plainly unlawful because it just was purely a waiting list, then that's something that you could challenge by way of judicial review. Or if the other point I'd make is if you're unclear as to how, because often there's a lack of transparency into why some people are being accommodated and some people aren't, or how big the waiting list is for Part 7 accommodation. These are all questions you can ask in Freedom of Information requests and see if any patterns are emerging. And then if, for example, it turns out that disabled households simply aren't being accommodated and they're waiting much longer than anyone else, then you can start thinking about the public sector equality duty. It's a very difficult question to answer in the abstract, easier to answer with specific facts. Martin will probably disagree with me on that, but...
Well, interestingly enough, in the Imam case, not only did they not have a list, they didn't even know how many households they had in unsuitable accommodation, never mind keeping records of them. But that only came out later, so that isn't part of the judgment. Martin, do you want to add anything on this point about managing lists and priorities as between homeless households?
I mean, not really. I suppose the point I would make, and again, it's a point that arose in Imam, and I think probably in the Elkundi cases as well, that it's got to be actively managed. There's a real sense, certainly in the what was called the temporary accommodation policy in the Imam case, that you went onto it and then it was just completely static, and nothing. Your case was never then reconsidered. Whereas what may often happen is that if you have a more sort of thorough audit of what your adapted or adaptable property is, then you may be able to move people from one to another. Whereas the sense of the way it was approached in Imam was that she went into her accommodation and just stayed there until the right thing came up, rather than actively considering what you could do about perhaps moving the stock around. And again, it's one of those things that if you haven't done that, if you haven't got a policy that does that, then are you taking all reasonable steps?
Martin, I have another question in the Q&A, which I think is one for you. Congratulations, and this I think is to all of us, on confirming a very important principle for homeless persons. I'm bound to ask, I appreciate this is a difficult question to answer, do you envisage any possibility of permission to appeal being sought, given the facts for the local authorities were so bad? Well, I can say that both local authorities did seek permission to appeal, but Martin, perhaps you can explain what happened with that and what's happening next.
Yes, I mean, in the Imam case, the permission to appeal was sought mainly on two main bases. One was that it was unclear exactly how resources should be dealt with, and the other was that the way that the court sought to require authorities to have recourse to their Part 6 stock, as opposed to Part 7, was in some way in conflict with the with its duties. I think Croydon may decide to appeal to the Supreme Court, but if they did, what may militate against that is that the case has been remitted to the High Court, so they may decide that they are going to prefer to just fight the case out then, and then if they still don't like the outcome, appeal that. We've got, I think, just over 2 weeks now to find out whether they lodge an appeal to the Supreme Court. I suspect they may do so because if they don't challenge this now, it may be difficult for them to then say, well, we want to challenge it on another go. So I expect they probably will do. On Elkundi, Zia will be in a better position to comment. Again, they applied for permission to appeal, as I understand it, on all of the points they lost on and it's one where they may well apply because they've got no reason not to, really, except they'll lose.
Well,
Zia, do you want to add to that?
I mean, they have applied for permission to appeal. One of their grounds for appeal is that the judgment will encourage local authorities effectively, they don't say this, but effectively try it on, so almost act in bad faith by saying that accommodation is suitable for the short term, whereas they say their construction of statute can mean that local authorities can behave far more honourably by accepting that people are in unsuitable accommodation, but not actually providing them with suitable accommodation. My feeling is, I mean, I haven't heard back about whether the Court of Appeal has given them permission to appeal or not. I would be surprised, given the way that the hearing went and the emphatic nature of the judgments, I'd be surprised if Birmingham got permission from the Court of Appeal. And then they've got a decision to make, because they've got what I think is a really good judgment, Mrs. Justice Steen, which didn't prove to be that difficult to uphold in the Court of Appeal. And now they've got a unanimous judgment of the Court of Appeal. And their point is that the main housing duty is not immediate. I mean, I don't know. I mean, I was involved in Ali in Birmingham, and I didn't, the Airways case, I didn't think that would get permission from the Supreme Court, and it did. And then the Supreme Court completely overruled the Court of Appeal. So what do I know? So anything is possible, but when you get to the Supreme Court stage, I mean, they might get, it depends what clearly this is a point Birmingham wanted to run for a long time, because they were flirting with this point for 2 or 3 years. And I don't know how much to the bitter end they're determined to run it. I mean, their costs must be phenomenal. I don't know how much further they want to run with it.
I mean, sometimes the Supreme Court grants permission. You get the sense that they do it just to shut down debate once and for all. Yeah. But yeah, you're right. It's a very strong Court of Appeal judgment, and yeah, and the argument that it's not an immediate duty is a very difficult one, because it creates this gap.
Yeah, one thing I found interesting in the Court of Appeal, and took me a little while to get around really, was that in the Birmingham Skeleton argument, they spent quite a long time setting up why shall meant it only had to be done in the future. But in the actual, I think on day one of the hearing, they pretty quickly accepted that shall simply meant must. So if they've accepted that shall means must, one of the main planks of their appeal, their arguments in the Court of Appeal has disappeared. We'll wait and see.
All right. Well, Zia, you may not have noticed that CLP have posted in the Q&A that the Court of Appeal did in fact refuse permission to Birmingham.
Oh, I didn't know
that. So it's not going anywhere yet, but that doesn't necessarily mean it's an end to it. So thank you very much, everyone, for joining us today. I don't think that we have any upcoming seminars that are planned, unless anyone wants to correct me.
Or isn't there one on homelessness coming up towards the end of May? I may be wrong, and I thought there was.
There may be. Well, if there is, then I very much hope that you can join us for that one as well. Thank you again, and thank you to Zia and Martin, and thank you, Ray, for managing the slides. And we'll see you all again soon.